Hi, friends. Welcome to the live broadcast of Spread Law, and we are today having a very esteemed guest, Mr. G. R. Raghavender. He's the Joint Secretary, Ministry of Law and Justice, Government of India. And what we are going to discuss today is that what the government is doing when it comes to improving the legal system. Because what happens that India is a country where people think that our justice system is recognized by one famous line of a Hindi film in which Sunny Deol says "Tariq par Tariq." So we keep getting dates, and that is the perception which the people have when it comes to Indian justice delivery system. But when it comes to government, obviously the government is aware about the problems faced by the common people, and that's why many steps are being taken. But when it comes to the ordinary litigant, when it comes to the ordinary people, they are not aware what the government is doing. And today, to talk about these things, we are now joined by Mr. G. R. Raghavender. He is a very esteemed member who has agreed to join our broadcast today. He is the Joint Secretary in Ministry of Law, and he'll be telling us what the government is doing.
Namaskar.
So welcome to the broadcast, Mr. Raghavender. I'm very happy and I'm very thankful to you that you have in fact agreed to come on the broadcast, because when it comes to the government functionaries, generally the people do not agree to talk, but you have graced this particular broadcast, and I'm happy and I'm thankful to you that you have come here. And so I want to know, like, when it comes to the general perception about the Indian legal system, people identify with the legal system as Tariq per Tariq. But are we going to change it in the near future, sir?
Yeah, thank you, Mr. Sumit Natpal, advocate, and also the CEO of the Spread Law, inviting me to speak to you and your colleagues, and also various other legal experts and advocates and law students and teachers. And it's very important topic, especially during this COVID pandemic. So, what government is doing in collaboration with the Supreme Court and High Courts, and what policies have been implemented, then how courts could function with the leverage of ICT, information communication technology, and and improve the access to justice, access to timely and cheaper justice. That is the main aim of the Constitution. In preamble, it's clearly written that justice, social, economic, and political. Yeah, you mentioned about the Tariq per Tariq that relates to pendency.
There is some problem when it comes to the network, sir.
Yeah.
So I think there is some problem when it comes to the network.
My voice is audible?
We are in fact not able to hear properly.
My voice is audible now? Hello?
So I think there is some problem with the network. Yeah, now I think you can start, sir. So can we start, sir?
Hello.
Yeah, we can.
Yeah,
start,
am I audible now? Clear?
Yes.
Yeah,
yes.
Thank you. Thanks for inviting me, Sumit, to talk on various important issues, various initiatives taken by Department of Justice, Ministry of Law and Justice, under the leadership of respected Sri Ravi Shankar Prasad, our Honorable Minister for Law and Justice, and also IT and Communications. And it's a double advantage that one minister is looking after both departments, and it has helped entire court systems in India to leverage information communication technologies very well, and then start functioning immediately during this COVID lockdown to improve the access to speedy and timely justice is very, very important. As you all know that justice, social, economic, political, and it's explained in the preamble. That is the heart and soul of our Indian Constitution. And it's very important for the courts and government to work together. And two important legs of our pillars of our democratic system to improve the access to justice. You have rightly mentioned about the Tariq ke upar Tariq. If you
Yes,
remember,
yes,
the government has been giving a lot of focus on that. Even in economic survey, if you look at the economic survey of the 2018, right from the beginning of the economic survey of the 2018 and followed in 19 and recent economic survey, one chapter has been exclusively dedicated to the pendency and what are the government policies, how it is working with the judiciary to improve the access to justice and reduce the pendency. That's what it mentions various steps taken and various steps which are going to be taken, which are in the framework of implementation. So this is very, very important step. And even Honorable Prime Minister, while speaking in the event of 150th year anniversary of the Allahabad High Court, he mentions about the importance of reducing the pendency. He says that burden is not only on the judiciary, it's also on the government, because around 40% of the litigation pending in the courts comes from the government.
yes,
So,
yes,
then the Ministry of Law started putting a lot of focus on this, how to reduce the government litigation. So, if you are aware, there is a portal called LIMS, Legal Information Management Based Systems. In this,
yes.
all the ministries and departments, their pending litigation, they feed information and data, and all ministries and departments are appointed a nodal officer. So each nodal officer ministry department looks into the cases pending in various courts, Supreme Court, High Court, and District Courts. The information is feeded, the dates given for the augments, and it gives a lot of information about the steps taken to reduce the time taken here, delay in filing the affidavits, names of the ASGs and senior government councils who are
Yes.
associated with that particular department and dealing with the cases. So this has helped a lot to understand so why delays are happening, and
And
at higher levels meetings do take place, and monthly meetings taken by the each department, and quarterly meetings taken by the law ministry, calling all the nodal officers of various departments to tighten the belts so no delay happens in dealing with the government litigation. Yeah.
I'm very thankful to you that you have started this session in such a beautiful way and you have informed what the Prime Minister thinks and how things are moving forward. But when it comes to new technologies, when it comes to implementing the e-court system, when it comes to implementing technology in the legal system, because when we see right now India is facing, in fact the whole world is facing this COVID pandemic, and that's why the courts are functioning in a digital way. We have seen hearings through the video conferencing method. But when it comes to e-courts, what is the future of Indian legal system? How do we see like trial happening through video conferencing? Is it possible, and is it a part of the e-court project which the government is dealing right now? What is the e-court project, what you have done, and do you think that this trial can happen through video conferencing? I would like you to answer, sir.
Yeah, in 2015, Supreme Court came out with a document, the National Vision document on, leveraging ICT for improving the court functioning. And then the birth of e-courts project is a central sector project, which is funded by the government of India. There is a planned budget which is allocated under the particular heading by the Department of Expenditure in every year financial budget. And this money is allocated to there is a Supreme E-Committee of the Supreme Court. So this is chaired at present by Justice Chandrachud, sir. And the committee, looks into the implementation of e-courts project. So the successful implementation of phase one, phase two. Now you're moving towards phase three. So DPR is being prepared, and what are the new areas, new ICT uh, things to be covered, so that courts start working in a disruptive manner and improving the access to justice, reducing the time, and also access to cheaper justice. That is the main motto of the e-courts project. When was it was introduced in 2015. So in 2015 to 19, the phase one started. So in phase one, basically, the idea was to digitize all the codes and introduce all ICT facilities.
Sir,
So
could you
in
just
this
explain for our
attempt,
viewers what is ICT? Could you just
yeah,
explain to people who do not know what
I,
is ICT?
yeah. That is, yeah, information and communication technologies.
Okay.
The information and communication technologies, shortly ICT. So phase one started, in fact, 2011 to 15. So when this document came and then project was implemented, so computerization of course has taken place. And 14,249 codes were computerized till 2015, 2011 to 15. So that was the main disruptive thing happened while introducing the technology, digitizing the codes and all that. And Wi-Fi connection was given to the courts. So not only giving the computerization, giving internet facility through Wi-Fi. So it was given at the time to 13,672 codes, and then computerization of more than 14,200 codes, and laptops were distributed to judicial officers. So understand, more than 14,000 laptops were distributed to the judicial officers, not only in not only the judges of high court, district and subordinate courts. So that's what the main focus of the entire e-court project, to
Yes, yes.
right from the roots to improving the system, making it more digital friendly, and then using this technology to reduce the time taken, and reducing the delays and then pendency and all that. So e-court services portal was launched. So the case information system software, it's called CAS software, was introduced. So now various versions of it is a three. Earlier was version 3 was there, version 3.1 was there. Now the entire portal has moved to the now new version is introduced, called version CAS version, case information system version 2.0. So it is everywhere. And then another disruptive thing was done during the phase one. That is, I'm talking about pre 2015. That is now helping even at the district courts. During this COVID pandemic, many district courts started doing video conferencing facility for dealing the cases. That was possible because by the time of 2015, 448 courts, district courts I'm talking about, given the facility of video conferencing.
Yes,
And
yes.
then and then 342 jails were also given video conferencing, which
Okay.
includes our Tihar jail. I remember in 2019, during the same month, May, June, I just wanted to visit on weekend to Tihar jail to see how the system being utilized. Luckily, at the time, not only the legal aid cell were functioning, various lawyers was sitting there and then giving advice to the jail inmates. Also, just a video conference concluded when I entered there. So the facilities, the money spent. I visited two such video conferences in two jails of Bihar, and with all the equipment available, no, I felt very happy that it is being utilized at the time. And then phase two started with more, more pumping of funds, and more work has been undertaken in phase two. Phase two was
Sir,
2016 to till now, 220.
I'm
Here,
sorry.
if you look at, if you listen to the figures, you will
Okay,
be
okay.
surprised.
Yes, yes.
The ICT enabled courts now increased to 16,845.
Okay.
Video conferencing, video conferencing facility available in 3,240 district court complexes,
Yes,
and
yes.
1,280 jails nearly have the video conferencing facility. So this has totally changed. And then improving it further. So what government has done, they engage the BSNL to provide the Wi-Fi facility, improve its bandwidth. So
Yes.
when in the first phase it was given only 2 Mbps. Now with the minimum 10 Mbps for the small codes, bigger codes it may be 60 Mbps or 90 Mbps. For total 2,992 code complexes, this project is being implemented. Now it is almost completed in 2,803 complexes. Only few areas where hilly areas are there, where laying of a fiber cable or optic cable is a bigger problem. So alternatives like satellite connection that is being considered there. Gujarat is already covered under this project. That's why Gujarat were left out in this BSNL WAN project. It's been hugely successful, and then it has really changed the entire functioning of this thing, codes there. And also, the e-codes phase 2 introduced various electronic tools
Yes.
on the web portal. Now, when judge goes and sits in the court hall, sitting on the bench, on a laptop, you can open and see various electronic tools. So using these tools, so he can, without wasting the time, waiting for the files and all, he can see how many cases are there. All kind on the on his docket, and dashboard. He can see, for example, how many cases, criminal cases, on civil cases, various kinds of data he can see, and the time taken, and the entire history of the case. You can see. You can see that in last hearing what exactly happened. So just with the bird's eye view, you can get the information on the all the cases listed on that particular day. And this facility has been provided to the judges in a special app made for them. It is not available on the
Okay.
Android Play Store or App Store of iPhone. It is
Hmm.
specially sent to them by Telegram app link. So they download this particular app called Justice app. So
Justice.
all the tools available
Hmm.
on the e-court services portal is made available to them. So anywhere, anytime that respected judge Saab can open his mobile app and see tomorrow what I'm going to do. So what are
Okay.
the important cases?
This is very
So which
interesting.
is
This is,
which is
sir,
1 year
normally.
old cases, 2 year old cases, 5 year old pending, 10 year, 20 year old pending. So he can prioritize those cases, that he will take those cases first and then finish them off. And this kind of planning he can do.
Sir,
And
this was not known to
this was
anyone that there is an app for the judges where they can,
yeah.
in fact, see those cases which are like pending for more than 5 years, 10 years, and they can prioritize them. This was not known to anyone. In fact, people
Yeah.
should know that the judges have got this kind of data where they prioritize their cases. This is very interesting, sir. But
Yeah,
when it
more
comes
than
to,
more than 13,000 district judges in India are using this, and it is being it's become very popular. So we have made a rule that in commercial courts, the judges sitting in the commercial courts
yes,
mandatorily use this app so that no delay happens dealing with the commercial cases. And then the similar facility has been given to litigants and lawyers. You must have heard about it, or you must have already
we have
downloaded
seen,
e-court
we have
services app.
e-court services app. That is very good.
So it has almost similar electronic tools given to the judges, but a couple of tools are different from lawyers, because the functioning of judges are different. So those tools are made available. Those are not necessary for the lawyers, so that have not been made available. Otherwise, the common things are common. And one is, especially one tool is provided, that is generating a barcode for each case and scanning this barcode and find out the real-time information about a particular case which is going to be heard in a particular court hall. So this is the great facility. When I showed it to World Bank team and about group of Central Asian and African countries who gathered for the World Bank's Ease of Doing Business drive in Dubai, as of overall 45, when I made a presentation, they were all wondering that such facility is given by India. And they were saying that, well, because India has the IT in the field, we have a comparative advantage. So we are able to. Many people were asking about the API and how you have done that and all that. So it's completely prepared in-house by the National Informatics Center, NIC, under the Ministry of IT. So
So in fact,
giving
I was Googling when I was looking for some information when it comes to e-courts. I saw a presentation done by some people in Bangladesh, and they were in fact discussing how India has implemented the e-court system. They were taking cues from India. I saw a presentation. It was presented somewhere in Bangladesh. The judicial officers of Bangladesh were discussing something. So I got a presentation. This means like Indian government is really doing good work when it comes to e-commerce, e-court system and implementing IT into the court systems.
Yeah, my department has spent some amount of money to on the outreach program. Also, many people are not aware that creating posters and creating radio jingles, popularizing these electronic tools availability, and various posters. We sent SMS through eSampark and made posters and spread it through social media. And the posters have been created in various languages. 22 official languages as provided in the Constitution. Been sent to all the district courts because I visited many high courts and district courts. I could see that these posters are made available for the public, especially the lawyers and litigants. So this is what done in the phase 2. The phase 3 is the next step forward. In a phase 3, activities have already become popular. So one of the phase 3 activities which have already been taken place, that is the virtual courts. For example, in Delhi, virtual court has been launched for the traffic challan cases. You know that has become very, very popular. More than 250,000 traffic challan cases have been solved using the virtual courts. Especially, virtual courts are very, very important. Dealing with the negotiable instrument acts, section 138 check bounce cases. So unnecessary delay and pendency happening in the courts can be reduced through virtual courts. But virtual courts are going to play, and video conference are going to play key role, especially during this COVID pandemic. But it cannot replace the physical courts when it is going to be normal, when things are going to be normal, when we enter the new normal times. And then this video conferencing and the virtual courts are going to help us in a different way. But this will continue, but these are not going to replace actual courts. That's what Justice Chandrachud said in his recent webinar. So that we should remember. And another important area it is being focused as is the cloud infrastructure. So improving the cloud infrastructure. And then most important thing is using most cutting edge disruptive technologies like artificial intelligence, data analysis. So using this to analyze the already given data in the National Judicial Data Grid. So many of you must have seen the National Judicial Data Grid. It gives 13 crore cases available, and more than 10,000 case orders are available. It gives district-wise pendency. If you look at the portal, if you go to NJDJ, National Judicial Data Grid, you can see the pendency of distinct subordinate courts, pendency in high courts, If you look at the pendency, of course, Supreme Court maintains here on its website separate pendency details. If you look at the pendency of the Supreme Court, it's 69,000 cases, and pendency of high courts around 45 lakhs. And then pendency of district and subordinate courts, it comes to 3.24 lakhs. Out of 3.24 lakhs, more than 2 crores are criminal cases. So a lot of focus should be given on the improving the delays and reducing the delays in the criminal cases. So there is a conference which is called Chief Ministers and Chief Justices of High Courts Conference takes place, which formulates the legal policy to be implemented by the most of the high courts. So state governments and high courts work closely. One of the decisions taken here in this meeting is to set up area committees which examine the cases more than 5 years, 10 years, 20 years like this. So Supreme Court has set up such an area committee. All high courts have set up such kind of area committee. We're focusing on this. What plan of action should be there to reduce pendency of cases more than 20 years, 10 years, 5 years, etc. To your surprise, do you know that such area committee is functioning even in district courts? It's functioning even in district courts, all district courts of the country. So principal judge of the district courts chairs this meeting, takes a decision, asking his other the judges to put more focus on the cases pending more than 5 years, 10 years, 20 years, or 30 years more. So this is happening. But question comes here, all these things can be done using the technology which is already been provided in ICT technology provided in phase 1, phase 2. The plans of the phase 3 possible when the vacancies are filled up and then manpower is available and infrastructure is available in various areas. And then question the point you were mentioning about the judge population ratio.
So one thing I wanted to ask you, when it comes to virtual courts, my question is it possible that tomorrow a lawyer sitting in Delhi is addressing a court in Mumbai? Is it possible through virtual courts? Can we see a scenario like that in future?
That is going to be possible. E-filing, you must have seen the demonstration of the e-filing made, the 2.0 e-filing portal, which was demonstrated by the Honorable Chief Justice of India, Justice Bobde, and also Justice Chandrachud. And my friend Ashwant Goswami, the registrar who's working, he himself a computer engineer, electronics engineer, come a judge, a district judge from Maharashtra, is posted in Supreme Court as a registrar. And when you can go back and see that video again. So various disruptive steps have been done, included there. Seamlessly, it can be done 24 hours. It's available. All documents can be filed apart from the petition. The court fee and other fee can be filed either through credit card or debit card, or using even Paytm and internet banking, all these, and also UPI. So I never heard of such kind of platform, payment gateway being provided, which is very comprehensive and inclusive, and it's very important. So now, but e-filing facilities are already made available in the district subordinate courts of Delhi. You can go to the district court's website. You can see that e-filing facility for the commercial court made available. Similarly, Mumbai High Court has also made available. Karnataka High Court has made available, and they are going to apply it for the commercial court soon. Similarly, the Kolkata High Court is going to do that. So many high courts have a computer committee. Just like the E-committee of the Supreme Court, they have computer committees. There is a registrar of computer, and one judge chairs this computer committee, and the decision taken is submitted to the full court of committee, chaired by the Chief Justice of that particular High Court. So full court takes a decision and implements this, whether virtual courts has to be done, whether Sumit Nagpal participating in the virtual court matter from Mumbai sitting in Delhi need not be traveling during these COVID times because there is no travel facility available. So all these things are being envisaged and implemented, planned, to improve the access to justice. That court's functionaries will not be hampered due to the special circumstances, unforeseen circumstances created by
Sir,
the COVID pandemic.
sir, we will be closing this topic and moving to the next topic. I just want one little question from you, answer from you, that when it comes to trials, I'm talking about trial in the trial court, district courts. You are saying that it is not possible. Physical courts are there, and it will remain like that. Sir, can you have a little more clarity? Very short answer, sir.
Actually, what I was trying to say that I was just parroting the same words of the Justice Chandachud, saying that the virtual courts and then video conferencing is not going to replace the actual physical courts, but these are going to come to help the in a day-to-day hearing. It will not be happening now what is happening now because of these extraordinary circumstances. Then the normal day-to-day hearing will happen, but some when there is a need that if Sumit Nagpal is not going to Mumbai for some reasons, he may request for the video conferencing. That facility is available, that can be made in that
Okay.
case, because Mr. Nagpal is not going there, case won't be adjourned.
Yes, yes, yes.
Yeah,
Fine.
that is the difference. That is the
We
difference.
understand.
And then, new disruptive things are happening. I would like to mention one important case, that is Pradyumna Bist case. So
Yes,
in this case, Supreme Court said that CCTV cameras have to be installed in all district court complexes.
yes.
So our department, in coordination with the Ministry of Information Technology and also NIC, developed a kind of standard operation procedures, and also the what kind of technology is required, what has to be the minimum standards required for the technology to be installed. And then pilot project was introduced in the district courts of Gurgaon, and then it was very much appreciated. Now it has been done in most of the almost 90% of district courts in the country have these CCTV facilities. And one more thing happened last year, that was introducing live streaming in Supreme Court, especially in the matter of cases involving the constitutional importance. So this case was filed by a law intern called Swapnil Patil, and another PIL was filed by Indira Jaising, and another PIL filed by Matthew Nadumbra. So three PIL was combined together and examined, and Supreme Court gave direction to government and to prepare guidelines for the live streaming.
Okay,
So
sir.
we work with Attorney General, respected Sri K.K. Venugopal, and this was prepared, and the Honorable Minister also approved, and then this was filed before the Supreme Court. Supreme Court approved it, and then the technology is supposed to be made available to the Supreme Court by NIC, the National Informatics Center under the MIT. So the everything must be available. Now it is for the Supreme Court to take a decision when they should start using this technology of live streaming. So, for instance, the Calcutta High Court recently started live streaming of cases in some instances.
Okay. Sir,
Telangana High Court also started the live streaming of cases in some instances. So now it started. So
it is
there are
that.
various advantages live streaming starts, because court hall will not be overcrowded. Even guys need not go and sit in the court hall to learn what is happening there. Sitting
Yes,
in
yes.
your chamber, sitting in your home, and law professors from their universities, law students from universities, researchers, anyone can get access to that and then learn when such important cases are being argued and heard in Supreme Court, especially the court hall room number one.
Fine, sir. Thanks a lot,
Yeah.
sir. We are now moving to the second topic. And the second topic is very important when it comes to a country like India, sir. Second topic is judge to population ratio. because India is a country, when it comes to the population, we are more than 130 crore people, and when it comes to the number of judges we have, the ratio is like very poor as compared to the developed countries, as compared to the Western countries. So, what is government doing to improve this particular ratio? Because we need more judges, we need more judges at remote places, at rural areas where the access to justice is very difficult for people in the rural India to get justice. So, what we are doing to improve this ratio, and are we seeing some increase in the number of judges? And one more thing I would like to know, that there was an idea that there should be one common exam in India when it comes to selecting judges. If you can talk about
Yeah,
that, sir.
yeah, yeah. So it's a very important topic, and academically and also officially, it always entices me, just to population ratio. But everything cannot be compared with the Western developed countries, because the way the legal system functions there, the way the people and public respond to there, it all depends on the socio-economic, cultural, educational background, and also the awareness and also willingness to go and fight in the courts and filing cases with the drop of the hat. So that is very, very important. But simply saying this, we can't avoid abdicate the responsibility of having more judges and having more courts, and also reducing the pendency. Already you said very outset of this webinar about the Tariq ke upar Tariq, the famous statement of Sunny Diol. And then that is the big thing. So how this judge to population ratio is there in India? So already I mentioned about the pendency of 69,000 cases in Supreme Court, 45 lakhs in all 25 high courts, and 3.24 crore pending cases in our more than 3,300 court complexes in the district court and subordinate court complexes in the country. So if you look at the Supreme Court, there are 35 sanctions, and all 35 posts have been filled up. So recently, the number has been increased, and then we filled up those new increased numbers also. Total, not a single vacancy is there. And then coming to high courts, government is working close hand with the collegium to fill up the cases. So recently, there is an increase in filling up of cases. So 543 high court judges have been appointed recently. Um, and 464 additional judges have been appointed. And from this the count I'm giving from around 2014 to till date. But if you look at the district and subordinate courts vacancies, it is a big problem. Here, the question of just to population ratio normally applied. So,
Yes.
and then compared. So in West, it is somewhere around 15. In India, is the less than 50 or abysmal and all that. If you look at the total sanction strength, in 2014, it was 19,518, the sanction strength.
Yes.
Now there is an increase of more than 2,000. Now at present, the sanction strength is 24,064. This is the number of judges to be appointed, 24,000 judges. So now 19,160 judges have been appointed, a vacancy of 4,900 is there. So, and now, as you said, the government is planning the more positive to introduce all India Judicial Services.
Yes.
So, in 42nd Amendment, a new article was introduced. That is, article amendment was taken place in Article 312. That creation of All India Services. A new All India Services has to be created. That is All India Judicial Service. So this was done with the purpose of introducing a new blood in the judiciary, just like civil servants who take UPSC civil services examination. And in 1992, in All India Judges Judges Association case, Supreme Court itself has said that that has been done. Amendment was done in 42nd Amendment long back in 1976. Why this has not been implemented? Government should take steps to introduce this court set. Then he said you set aside 25% of post or direct recruitment. India Judicial Service guys can come and sit, the young lawyers, and what should be the method of recruitment? Everything government can decide. But question came, how it should be done. So if you look at the various law commission report, law
Yes.
commission report 14, it suggested. When was it? Is law commission report 14? And not only you, it was submitted before my birth, late back in early 1960 and 1961. Then it was said that All India Judicial Service should come. This
Yes.
came before amendment took place. And then Law Commission Report 77, Law Commission Report 116. So various
Yes.
Law Commission reports supported this. And then various committees also supported this. But still, this is not happening because lack of political will and all that. But my at present Minister, respected Ravi Shankar Prasad ji, the Minister of Law and Justice, has again and again saying that government is keen to introduce this provided there is a consensus among the judiciary, because various
Yes.
high courts have not agreed to that. Of course, few have agreed, few have said some changes needed about the policy, and few said no, you can't do this, you can't take away the control of high court over appointment of judges, judiciary, and all that. So what district and subordinate judiciary. This is as per the chapter 6 of the constitution. I know they are worried about the Article 235, which gives powers to the High Court and governor in appointing and also the managing the services of the district judges. So that is the issue. Again, coming back to the judge population ratio, judge to
Yes.
population ratio. In 2014, judge to population ratio was somewhere 16.11%.
Yes.
Now, at present, it is 19.5%. So, how this is calculated? This is calculated on the basis of the latest census. Last census took place in 2011. So, the population figure provided in that and the number of judges available now, that percentage comes to judge to population ratio. Now it is 19.5% roughly.
Yes. Yes.
So is it okay? So it is there any need to improve this? Why more? And then there is a vacancy of more than 4,900, means nearly about 5,000 judges need to be appointed fresh. So why delay is happening? That's why Supreme Court in its decision in Malik Majar Sultan case. So Malik Majar Sultan Saab is a principal judge of a family court in Uttarakhand. This is a case filed by him, the various service conditions and filling up of vacancies and all that. So Supreme Court uh, got to know, while examining the various affidavits filed by the high courts, affidavit filed by the state governments, because it's very interesting how this district judges appointments takes place. There is a higher judicial service, the assistant district judge, ADJ, and senior judge, and all that. That is appointment takes place. Appointment takes place. There is a direct recruitment in which lawyers with 7 years experience they apply, and the promotion, by promotion also it happens. And there is a subordinate service, senior judge, senior civil judge senior, and also civil judge junior categories. Their direct recruitment and promotions take place. So here most of the in all 25 high courts, these 25 high courts appoint, their responsibility is appointment of higher judicial services in district courts and subordinate courts. So central government never come into picture. What central government role, it is limited to appointment of High Court judges, Supreme Court judges, that too after collegium decides. You know that.
Oh,
So there also we don't have powers to appoint, but entire power is with the collegium. It's a selection of judges. That's what my honorable law minister Ravishankar Prasad ji says. But the government doesn't want to act like a post office. We do
yeah.
apply our mind, finally, giving a shape to that proposal, and then finally appointing those judges. But unlike in this appointment of Government of India's and Department of Justice role in appointment of High Court judge and Supreme Court, in district and subordinate, we have no role at all. All higher judicial services in district appointed by High Court.
Yes.
And then subordinate judicial services, 50% by the High Court, 50% by the state public service commissions.
Yes.
So again, there is no role of Supreme Court. That's why, considering this, Supreme Court passed order. So why delay is happening? Delay is happening because of High Courts and state government, not because of central government. In Malik Mazhar Sultan case, it has set up schedule.
Not be blamed for Tariq.
Supreme Court set a beautiful time schedule. It says the appointment work, giving the advertisement notification of vacancies should start from 31st of March, and exam should be held by the judiciary. Exam should be held, and interview should be completed by 31st of October. So the process should start on 31st March and it should conclude on 31st October. Their selection and the list should come out. So okay, that is the thing.
So I'll just
and then come to judge population ratio. So there is one case, Supreme Court, it is called Imtiaz Ahmed case. It's very, very important case. Imtiaz Ahmed versus State of Uttar Pradesh.
Yes.
In this case, delay was happening. Is a case of matter of more than 20 years delay. So why this delay happening? Because of number of judges are less, number of courts are less, pendency is more. So how to deal with this? Then question of judge to population ratio arose in the minds of those respected judges sitting at the time when this case came up. I'm talking about in 2012. So it directed the Law Commission in 2012, Supreme Court. It said the Law Commission chairman and other members should examine that, whether they can evolve a scientific method like a judge to population ratio in assessment of requirement of additional courts and additional manpower dealing with the current pendency ratio.
Okay, so I think
Law Commission took 2 years.
Also. So it's time to take some calls. So one lawsuit.
Law Commission took 2 years. In 2014, Law Commission came out with its 245th report. Law Commission report of number of 245.
Yes.
In this, Law Commission says, it did a lot of empirical research to getting data and all that. Finally, it concludes and then comments that filling up of cases per capita filing of cases in India varies from geographical area to geographical area. It differs from north to south, east to west, and central to particular in state itself. It varies. So there's a lot of variance of data on per capita filing of cases geographically. That is number one. Number two, it also says it also varies as per the socio-economic cultural background of the people of that geographical area. That's number two. And also the awareness and legal awareness, willing to go to court and file the case and jalao that headaches and all that. That's another thing. So it says, coming to, if the situation is like this, then you are talking about judge to population ratio. Law Commission, the sentence I'm just underlining what Law Commission in the report 245 says. It says look, man, there is no data available.
Mm.
So, lack of data, and data is not maintained by neither by the high courts or the district and subordinate courts. So, scientific method can be evolved based on the authentic data, availability of data. When data is not available, we can't calculate a authentic judge to population ratio.
Yes, yes.
It varies. So it can't be calculated in Indian circumstances or present circumstances. It made a statement. Then everyone was surprised when the report came in 2014. Immediately, Supreme Court said it asked all the high courts, all the state governments, take a copy of the Law Commission 245 report, give your comments, submit in
Okay.
affidavits.
Okay.
That happened. Then once that came, it took some time. It took 2 years. You know how filing of affidavits, asking time. It took 2 years, and then 2016 it came. In
Yes, yes.
2016, it requested there is a committee in the Supreme Court called National Court Management Systems,
Mm.
NCMS.
Mm.
Uh, it asked the National Court Management Systems Committee of the Supreme Court to evolve a scientific method, requirement of calculation and assessment of requirement of additional courts, additional manpower. So what is the scientific method in assessing that?
Okay.
So
So,
the burden shifted from Law Commission to National Court Management Systems. So
yes, yes.
many people must be who are listening to this talk, is this webinar, watching this webinar, must be wondering what is this National Court Management Systems of the
Yes,
Supreme
yes.
Court. Some people must have heard about the E Committee of the Supreme Court or various committees of the Supreme Court. What is this
Mm-hmm.
committee? So luckily, I'm a member of National Court Management Systems of the Supreme Court. It
Okay.
is chaired by Justice Sikri Saab is chaired by this. I'm an ex officio member representing Department of Justice, especially
Okay.
the National Commission for Justice Delivery and Legal Reforms, for which I'm a mission director. In that capacity, I'm an ex officio member of this. So
Okay.
I
Really nice
just
to know this,
briefly
sir.
tell you
Sir,
what
sir,
it
sir,
is,
sir.
what does it
I
work.
just wanted to interrupt. Can we take one caller? The law student is waiting for a long time. Just one
Yeah,
question, if possible, sir.
yeah.
Okay.
Uh, let me, yeah, please.
Good
Just
evening,
a brief
sir.
question, then we can continue.
Yeah,
My name is Rohit Pradhan. I am from Symbiosis Law School, Hyderabad. First of
yeah,
all, I would like to extend my gratitude to Sumit Nagpal sir to give me this opportunity to attend this webinar. I would like to ask some questions which I need to do for my research paper. First question is regarding cyber attack. For example, it is pertinent to note that soon after the pandemic, people started to use Zoom video conferencing app, for example, and we saw that how cyber attacks were done, hackings were done, and personal data were taken. And now we are seeing changes in our judiciary, and there are court hearings done through video conferencing. Sir, is there any framework to deal with such issue? And what would be the remedy given to the party if their details are leaked out in the dark web or in the internet, which is not supposed to be? For example, in some very serious cases where the personal detail has to be circumscribed and not to be shared to the public. Sir.
yeah.
Okay.
Yeah, well, I'm not a cyber law expert, but as per my knowledge, I would like to tell you there is a concept of cyber security. So this it is totally it's a kind of accountability of an organization which has introduced this tool for the use of common people, that they give importance to cyber security and protect the data. So that has not been done when Zoom. I remember in the initial stages, I also used the Zoom. I felt is one of the very friendly meeting technology. available, webinar or video calling app. But when we heard this, and then immediately Home Ministry came into picture, and they issued direction not to use that, and including Supreme Court and other courts were using this, and they later on moved to video app. The video app is one of the apps created for the official work by the National Informatics Center, NIC, which is an autonomous body under the Ministry of Information and Technology. So yeah, and then there are some issues in the video app. So Supreme Court has, I think, apparently they've taken a decision recently to move to the Cisco systems with the licensing and all that. Cisco is another meeting app facility platform which provides things. Coming to data. So what happened? Your data is compromised and violated, and it is not protected. Unfortunately, in India, there is no comprehensive data protection law, which is equivalent to the GDPR of the European directives on the data protection. But the government of India, you all aware that Justice Sri Krishna Committee was appointed. Justice Sri Krishna Committee has given very comprehensive report covering all issues, including the issues you have mentioned.
Okay,
All these recommendations have been incorporated in the bill, data protection bill, which has been submitted by respected and honorable law, justice, and the IT and communication minister, Sri Ravishankar Prasad ji. This bill has been referred to the standing committee of the parliament. Hopefully, report will come soon after the lockdown ends. Maybe when monsoon session starts, when by the time the lockdown, the COVID pandemic threat will reduce. Hopefully, they will take up this, and the discussion will start in both houses of parliament for considering and passing of the data protection bill. So till then, these things have to be dealt with the various provisions of the IPC and
Other
IT
remedy laws.
Act and other provisions only. Otherwise, we don't have. So thank you
Thank you.
asking for a very important question. And then going back to the judge population ratio thing. So the duty was given to National Court Management System. I was trying to
Yes, sir.
explain what is this institution. So there is the concept of international framework for excellence of courts. International framework for court of excellence. This concept has followed, and membership is about more than 30 countries, and then 50 institutions of Australia, US, Indonesia, Singapore, New Zealand, and then many Central American, African countries are also member. So, what is this international, framework of court of excellence? It introduces a kind of performance measurement system in functioning of the courts, and also ranking of the courts. So what reforms to be introduced, case management systems, court management systems, so that improve the performance of the court, so the access to justice is improved. And the same, considering the same concept in India, the National Court Management System at the Supreme Court level introduced. But unlike it takes care of only the performance improvements, but not the performance evaluation and giving ranking. So
Yes.
that part is left off. And similar institutions have been introduced in High Court level also. There they call state court management systems. So
Yes.
I had the opportunity of attending one of the meeting of the Delhi State Court Management Systems when Justice Ravindra Bhatt sir was a High Court judge. Then a decision was taken to introduce virtual courts for traffic challans in Delhi. So I
Yes.
was the eyewitness of that decision when it was taken. So finally, the NCMS Committee of Supreme Court examined, developed a scientific method which is alternative to judge to population ratio, submitted an interim report. What does this report say? It says normally the judicial hours spent by the judges, the calculated on the basis of unit method system. Unit means how
Yes.
many cases per day dealt by the judge. It said that is not a scientific method. So X judge may be dealing with 50 cases per day. Y maybe must have dealt only 15 cases.
Yes.
So we can't compare in unit-wise 50, 50 and 15. But the
Yes.
number of judicial hours spent on 15 may be more than 50 cases, because all
Yes.
50 is just only, uh, sometimes, how the court system functions. So that's why they have developed called weightage disposal method. Is that it's a very most scientific method of assessing the judge's performance. It says, what is this method? It says the disposal is weighted by nature and complexity of the each unit or each case. So
Yes.
simply pass on हो गया या adjournment दे दिया या ex parte order दे दिया without trial and arguments. That is a different thing. Or judge and his entire research team putting lot of research in the back door and coming to the court hall and witnessing the trial and argument and taking the notes and going back again researching and then giving dictation and coming out with the final order. So,
Yes.
and imagine each case this kind of rigmarole of hard work going on, and you can't compare with the simply very easy cases which have been dealt with. So that's
Yes, sir.
what the scientific method submitted, and Supreme Court in the January 2017, and then asked my department to give the copy to all high courts and state governments. And the law minister himself wrote to all the high court chief justices and chief minister of the states to give importance to this mechanism, scientific mechanism, in assessing the performance of judges. So on that basis, how many new judges are required,
Okay. Okay. So
calculation
can
of
we?
that judicial have happened, then just to population ratio may increase based on that. So it is the scientific method. But the final report has been finalized and the NCMS has considered. Now it is for the Supreme Court to finalize and implement this system. So this
Okay, sir.
will happen. So this is about the present status of just to population ratio in India.
Okay, so we have like very less time, and the last topic I want to touch upon is time frame for completing the trial.
Yeah,
So there's a concept of time slotting, because some
yeah.
people I have heard, they suggest that for every process in the court, some time frame should be fixed. Some time slot should be fixed, that this is the time slot which will be available for the initial arguments. This will be the time slot which will be for recording of the statement of witnesses. So when it comes to time frame, so can you tell me what the government is thinking about it? Can we implement this kind of a system in India? Obviously, I can understand your concern that it is the judiciary which has to decide when it comes to the practical aspects of conducting a trial. But yes, you are dealing with many aspects, and do you think that this is a viable option which should be considered by the judiciary?
So if you look at our CPC provisions, we have time slots for everything. Filing the written statements and arguments, including the 30 days given for the writing the judgment by the judges. But whether in 30 days written argument to be filed and all this time, again, you also lawyer, you go to the judge, you seek extension, and he judge uses his discretion, and then the legislation made by the parliament giving that deadlines which is included in the CPC is not implemented. So this is what discussed in the Salem Bar Association case. Supreme Court says, okay, CPC may be giving that timeline, but the discretion of implementing them rests with the honorable judge. So it is for his discretion to whether to give extension or not. So because of that, this time powers are not being respected. So, what is the reason? The lack of coordination between bar and the bench. Both are responsible. So, for these timelines are not being done. So, one very good attempt has been made when the Commercial Code Act was introduced in 2015. So
Yes.
the reason why Commercial Code Act was introduced to give a fillip to ease of doing business, to improving the functioning of enforcing contracts in India, because enforcing contracts is the heart and soul of the entire indicators of ease of doing business. Whether it is starting the business, registering the company, getting the credit, getting electricity, paying taxes, and protecting the minority interest, trading across the borders, insolvency and bankruptcy, and all these indicators. Wherever implementation of these indicators, wherever trouble begins, that ends up as a commercial dispute. And that's what all these disputes have been defined in the Commercial Code Act, Section 2C, comprehensively, including the cases pertaining to intellectual property rights and contract agreements and everything, including trade secret agreement and everything, have been included in this. So unless and until timelines are followed, there will be a lot of delay in dealing these commercial disputes in the courts. And if any delay happens, it will be a big problem for the further foreign direct investment in India. So the investor will run away, the multinational corporation will close its shop, and you will also run away. If a matter gets stuck in the court for ages, like let's say that 10 years or 20 years, so they can't do the business. They come here to do the business.
Yes, sir.
For that reason, CPC has been amended only for the commercial courts. If you look at this Schedule 1 of the Commercial Code Act, it says there is a summary judgment for this. So
Yes.
timelines have been fixed. So there is a case management hearing. If you look at the CPC, order 9, order 10, 11, 12, examination of documents and all that already there. Still, you have been very streamlined, and case management here, pre-trial conference has been introduced. This is mostly the Western concept, which reduces the time, unnecessarily time on adjournments takes place during the trial and argument. That is reduced when you identify the documents, when you identify the list of witnesses, exchange all these things, and fix that, frame the issues, fix the dates of the trial and arguments in advance, and stick to those timelines, and also filing evidence in affidavit, how much time to be given to that, everything is decided. Timelines have been given there. No,
In fact,
if the
during my
timelines for the trial and timelines for the filing, issuing of summons, and the trial followed strictly, in 1 year, maximum 1 year, case will close. I'm talking maximum. It may take less time also. So, as per the data gathered from the commercial courts, 22 commercial courts of Delhi, in this year, year 2019, let's say that I've taken average of about 13,000 cases. What is the time taken? 700 cases average, 700 days average. Earlier it is to take 5 years. 5 years. And Mumbai, it is less than that, 270 days.
It is done.
The average time taken in 4 commercial courts. So this has already started in India. Only thing is, one should respect the law, Commercial Code Act, okay, and the timelines given in the CPC. If this starts functioning, and this improves the access to justice and protects the business interests, and it plays key role in improving the contribution of these industries to the economy, and also improving the India's rank in ease of doing business. Obviously, we may think of extending this CPC provision in general to other cases also. That's possible.
So that was, in fact, I was going to say this, that we certainly hope that very soon when it comes to timelines and other cases also, especially in family matters, because I have seen in family matters, I had in fact appeared in one family matter long time ago, and I asked the judge that, can you give me a shorter date? The judge said, the honorable judge, he said that I have 2,500 cases. Come and sit on my seat, and then you see whether you can get a earlier date or not. So I still remember how things are there in the Indian courts, and we certainly hope, sir, that soon this time-bound trial would be a reality in other type of cases. Obviously, Commercial Courts Act is a good start, and I can tell you, sir, I remember my session with Senior Advocate Vikas Pava. He mentioned one thing, what he experienced in Greece. He said that we were conducting trial in Greece, and what happened that the statement of all the witnesses were video recorded in one day, and it was over. So whatever that transcription work was there, the typist would type after seeing what is being said in the video. But at that time, this was a great way to save time. So in India also, we certainly hope that such things start happening, and we really hope, sir, when it comes to timelines, when it comes to e-courts, when it comes to the speedy justice, India, in fact, progresses. And I would just request you to give your concluding remarks, sir. Then we'll be ending this session because we are already out of time, sir.
Yeah. And thank you, Sumit. And my final remarks that, respect the law, respect the timelines, and then don't take unnecessary adjournments. Recently, Honorable Law Minister had written to the Chief Justices of Delhi High Court, Mumbai High Court, and Karnataka High Court, and also the Kolkata High Court, that directions may be, practice directions, in fact, may be issued, respecting the Order 17 Rule 1, that only and the three unforeseen circumstances the adjournments are sought, and then any more adjournments are sought, costs have to be imposed. At least in 50% cases, this has to be strictly implemented in case of commercial disputes, so that unnecessary delay which is happening can be stamped up. But this is possible only cooperation with judges and the lawyers, the bar and bench. So unless and until you ask for the adjournment, judge won't be giving adjournment all by himself. So my only request is, don't seek unnecessary adjournments. You know that when it is required, is required, because I am also student of law doing PhD in law, so and associated with so many lawyers, and know a bit of your art, and hopefully you play key role in improving the access to justice and delay in pendency. Thank you a lot. Thanks a lot.
Thank you, sir. And I'm really thankful to you that you found time and you interacted with us. And I really hope that people would be able to gain knowledge when it comes to the steps taken by the government, when it comes to improving the legal system. And people will be able to use these methods. You provided so much of information. And I'm really thankful to you, sir. And I'm really thankful to all the people who have joined us on this broadcast. I'm thankful to the students who had joined us on this particular broadcast. And at the end, I would request everyone to subscribe to our YouTube channel so that you can take part and you can see such broadcasts happening in future. Thank you, sir. Thanks a lot.
Thank you. Thanks a lot. Thank you.